one of the things that I find interesting about video games is that they are a very rich source of intellectual property, and almost any type of IP that you can think of will be in one type of video game or another, but there are a lot of pitfalls with those as well. And that's particularly with respect to people who are developing or working with people who develop video games themselves. But there are also some issues for people that play, particularly on the streaming side. If you publicize your video playing a game, and I know, my kids watch it, and I'm sure your kids do as well, there's some trademark and copyright issues there, and I'll touch on those as well. Kendall, if you could flip over to slide, I think 3. All right, so as I mentioned, we can have all types of different IP in video games. Most of the attention is on the copyright and the trademark side, and that's what the bulk of my talk is going to be on today. But I'm also going to, like I mentioned, talk about streaming videos and things like that. On the patent side, just to touch on it briefly, most of the patents that you would have in video games are related to the gaming infrastructure and the technology that the games are built on, like the graphic engines and the audio engines, as well as the network infrastructure, maybe the stuff that lets lots of multiple players play together at the same time from all over the world, and also the gaming hardware. There's a huge industry in gaming hardware, and in fact, just as one example, there's a trial going on now. It's actually a Zoom trial. It's in front of the jury, where Valve Corporation, the people that run Steam, were sued on a patent on a gaming controller, and there are about 1.6 million controllers at issue. And this was a patent that improved the controller by putting certain buttons on the bottom, so you can hold it and play with your fingers on the bottom as well. On the trade secret side, it's no different than any other industry. You're going to have trade secrets in software, trade secrets in your customers who sign up, and your marketing data, things like that. It's primarily a concern when you're dealing with people that move from company to company, particularly programmers. They're very fluid, and they move from one place to another, do a lot of contract jobs. And recently there was a tremendously expensive and large litigation involving programmers that were originally at a company called ZeniMax, and then left and ended up working on the development of the virtual reality headset. There were huge trade secret dispute. People brought source code with them they shouldn't. So that's just an area where you would expect to see things. But I'd like to now just move on to talk about copyrights in video games and just IP more generally. So let's see, we bump to the next slide, please. I think one more. There we go. Hang on, excuse me for a second. My video has disappeared. So let me see if I can get that back up again. Kendall, what slide are we on?
We're on slide 6.
Okay, I'm sorry. Yeah, I'm not seeing the slide that you're showing, but
that's strange. I'll do a reshare.
Yeah, let me, I have another window up in the background, and that seems to, maybe that's interfering with it. There we go.
Can you see it now?
Oh, that's much better.
Right.
Thank you. I don't know why it disappeared
Awesome.
from my screen, but
No
right, so let's back up just 1-2 slides, please. There we go. All right, so as I mentioned, you can have a tremendous amount of different types of IP issues raised with video games. And just as an example, particularly with the more complicated games that exist today, you can have IP in the software, but there's also graphic designs of the characters and the background. They're very rich characters themselves. So you can have IP protection for the characters in video games, and you can just think of all of the Nintendo characters you might see around. And a lot of them are fully scripted in a way that's similar to movies. So you have the soundtrack, you've got music behind it, there's written script, you have voice actors that are involved, the dialogue, you can have choreography for some of the live action scenes that are played out. And all of those are protectable, as well as the names and logos and things like that. And everybody that's involved with creating these types of materials can be a source of the intellectual property. So they can be working as employees, in which case the company might own them. They can be hired or licensing the software out. And as I'll mention later, it's important to be able to follow all these rights and keep track of what they all are, simply because you don't want to end up in a situation where you might have a game and realize after it leaves the shop that you don't have rights to do what you want to with it. And also the games, like every other type of entertainment, the ideas flow back and forth. You can have movies about games, you can have games about movies, and lots of alternative media. And so when you're looking at these rights that you have in a game, you also want to think of where else they might be able to be used. And then in that, make sure that at least you've thought about it and you've addressed it somewhere in the contract, so that later on you don't end up with the situation where you can no longer use your game or you can't release a sequel or something like that. Can we flip to the next slide? So, and this is an example, Angry Birds, for example, very popular game and an app, and there's movies, there's ringtones, there's sequels, there's toys, and all of these flowed out of a popular video game. So when one tip for you or your clients is document everything, make sure you know what all your rights are, and make sure you know what you can do and what you can't do, and you think about everything and all the options that might come up ahead of time. And it doesn't mean that there's any one right answer. You may not be able to do what you want to with it later on, but you at least should know about it, and think about other areas where IP might come in. One area that is somewhat difficult, a lot of people don't think of, is crowdsourced materials. In some games, you can have members of the public put in their own characters, put in their own gaming levels, maybe skins or new backgrounds that might get incorporated. And who owns those materials? And if the game, the developer likes it and they want to bring it in, there should be a mechanism to do that. So you want to think about how that's addressed. Usually it's put into the end user license agreements. But if you're allowing those types of additional materials to be submitted, you need to think about the ownership issues, and also whether you're going to get something submitted that might infringe a third party's copyrights or trademarks, for example. So these are all areas that could be of potential concern. Can we bump next slide? So focusing specifically on copyrights, in very brief summary, a copyright protects the creative aspects of the work, and you get the right to copy, distribute, display, and whatnot. And they're very long-lasting rights. They attach automatically when you save your program or you reduce it to a tangible form, language of the statute. But you still need to register your copyright with the Copyright Office if you actually want to file suit against an infringer. And so there are good reasons to register your copyrights in your game and the various subparts of it early in the process, about usually when you release the game or something, about that time. And I'm not used to being able to rely on someone else to flip the slide. So we can go to the next one, please. In looking at what type of protection you would get on a game, the game idea, the basic layout, the type of game it is it a bubble shooter? Is it a first-person shooter game? Is it an adventure game in some fantasy land? I mean, these are all basic ideas, and copyright won't protect that or the basic mechanisms of how the game works, but it does protect the particular way that that idea of the game is expressed in the layout of the graphics, the particular details of the types of character, and if you have a plot or narration, much like a book or a movie, you can protect those as well. It can be sometimes difficult to identify, where the line exists, but I've got a couple examples of ones where it's pretty clear that there's some copying going on. Next slide. One other area of copyright that limitation that won't be covered when you register your copyright in a game is the scenes of fare. These are standard stock things that you would expect in a particular type of game genre. So if I'm dealing with a Western game, you're going to have Indians and cowboys and black and white hats, characters, and all sorts of paraphernalia out there. If you have a zombie game or a post-apocalyptic landscape, there are certain things you're going to expect to find out there, and your copyright's not going to protect these type of features in them. Likewise, there's mergers. So if there's only a couple ways to do things, a power up, if a common thing is a box with a little red cross on it, that's the universal symbol. So you're not going to get a copyright on that, but there are a lot of ways you can augment those and put a lot of extra detail into your game, and that's where the protection is going to lie. Next slide. So this is just an example of copyright case that was filed. It was a number of years ago, but this was a company, Zeo Interactive, that came out with its Tetris-like game, and Tetris Holdings sued them for copyright infringement. And looking at the two pictures, you can probably appreciate why. And then looking at it, the court said this is not you can't copyright the idea of a falling puzzle game where the pieces interlock and they disappear. But what they ended up copying is not just the idea of the game, but all of the details about it, the way the blocks looked, the animation that happens, the particular way in which it moved from one section to the next. And as an example of an alternative type of game, which we can see on the next slide, the court pointed to, there we go, another type of bubble dropping game, a puzzle dropping game that was out at the same time called Dr. Mario. And you can see it's the same basic idea of a game, but the implementation details are very different. The blocks disappeared by making little characters, germs, or something like that. The graphics look different. And so it implements the same type of game, but it's a very different way. And this is an example of sort of the difference between protectable copyright and unprotectable idea. Here's another example. This was a recent lawsuit brought by the company that makes League of Legends, Riot Games. There was a Shanghai Montoon company came out with the game Mobile Legends. And it's not that they simply copied the idea of a multiplayer adventure game with wizards and battling orcs and things like that. They actually copied down to the smallest detail issues about where the environment was, the number of steps. You have pictures here, the way the stones were placed, where bushes were, and this is an example of what you shouldn't do. You can have the same basic idea, but you shouldn't copy things exactly. And in fact, in this case, for a variety of reasons, it was actually dropped in the U.S. It was moved to China, and the Chinese courts found that there was copyright infringement, and there was a multi-million-dollar damage award issued on that. But one thing, as a counterexample, in a game, if you were looking at something like a Grand Theft Auto, where it's set in a real environment, and you're modeling it after a city like LA or New York, there's going to be a lot more similarities based on that. So as long as you're not copying from the game that you want to emulate, but instead using real world unprotected sources as your inspiration, that's also an issue, because copyright requires, of course, that you have access and copying. Here, access was easy, copying is pretty clear, but there are ways to avoid that. You just don't want to duplicate the games. Next slide. So an important issue, of course, is also who owns the rights to the works. And under copyright, there are two options. One is if it's a work for hire, either an employee or independent contractor that works on a certain particular type of work. And if that's the case, the company that is the employer is the owner of the copyright. Otherwise, it's the person that creates the work, that's generally the owner by default, the author. And so it's important that in your contracts, if you're not sure, if it's not clearly an employee, even if it's an independent contractor, you want to make sure to include a copyright assignment clause. There is one of the 9 specified categories is audiovisual works, and you can certainly look at a video game as an audiovisual work, but there's question about whether software itself would be considered part of that. And that's an area where people tend to forget. If you hire a consultant to write your code, you want to make sure that you own that code at the end. Another area that people tend to overlook thinking about is the use of open source software. It's free. It does a lot of things. There's a lot of really good stuff out there that you can put in. But the open source software generally comes with a license that can have its own restrictions. Some of them may say you can use it, but you can't use it for commercial purposes. Other ones have what can be known as a copyleft license that says you can use it freely. But if you put it in your code, then you also need to make that code available to the public. And depending on what you're doing, you might not want the public to be able to get to your source code. So that's an additional area of, it's a tip just to where you want to make sure that when there's open source software, you're aware of what the obligations and restrictions are and that you comply with them. Otherwise, you may end up in a lawsuit where someone says you have to disclose your code. And if you lose, that could be a very damaging aspect for the business. Next slide. So on the registration, as I mentioned, games are audiovisual works, and you can register a copyright in a game. You could submit the entire game on a disc with the music and the video and the pictures and everything. And the registration will cover the entire thing. It'll cover the software and everything generated by the software. But you can also register independent subparts, and there can be some uses to that. Several games, and I forget the name, I think Riot and League of Legends and others, they have musical albums that come out. My son actually went to a performance at one point. Somebody was playing music from Final Fantasy. Totally separate from the game. The music is popular in its own right. And the marketing of the characters, sound effects and things like that, you may want to market these independent from the game. Thinking back to our Angry Bird example. And so having a separate registration on that product or work can be useful in terms of licensing, because then you have something very concrete that you can look at. One other area in which you have some copyright issues, and this has to do more with people that are playing games than writing them, is on gaming streaming of people playing and commenting on games. Twitch is a really big venue for this. You also have them on YouTube. And there can be issues because when you broadcast yourself playing a game and you can see the game and you can hear the game in the background, that's a derivative work of the copyrighted materials in the games. And it can be subject to takedown notices under the Digital Millennium Copyright Act. Recently, Nintendo, who was very litigious and aggressive about enforcing its IP rights, issued several hundred takedown notices to people that had videos up on Twitch, where they had videos of themselves streaming. You can also have issues on YouTube and elsewhere. One of the main factors in whether people get targeted for this is if there's a profit motive involved somewhere. So in looking at the types of takedown notices and who they were directed to, they were areas where people were selling maybe merchandise that was derived in some way from the video games. Maybe things look like some of the characters. If they had advertising on their website, so they were making money in some way. And it's a balancing act because it's free publicity. And a lot of the smaller gaming companies are quite happy to have it out there as long as they're not losing money from it. And if they don't need it, like Nintendo really doesn't need to have a lot of this out there, they can be more free to enforce. In addition to the playing music, music companies are also very aggressive about enforcing their music copyrights. And video games are no exception. A lot of them have background music in them. And so if you're playing and you're not thinking about it, or you've got music in the background, that can trigger the takedown notice. And some sites, Twitch and YouTube included, actually will filter out music that they think might be infringing a third person's rights. And they do that automatically, and part of it is to show that they're trying to enforce it. But it could mean that you post something without thinking about it, and then you get a black flag raised, and maybe your account gets locked and your video gets off. And so there are ways around it. Like I said, be careful, but at the same time, you know, that's there's a risk involved. So Another area that has been recently popular is you might have heard about the Fortnite and arguments about whether there was any protectable IP in dances. We've got a little video clip here that's playing. And in this case, Fortnite, the game itself is free to play, but they make money by letting people buy ways to customize their characters. And one of them was being able to buy particular dance moves that you could have your character do in the game. And many of these were inspired or directly copied by famous people. This what we're seeing here is a Carlton dance. We have Backpack Kid, 2 Milli Rapper, and a number of other people who had what they called their signature or their trademark, their copyrighted dances. And you know, if you're familiar with pop culture, you would look at it and you would know who they were from. And so the lawsuits were claiming that these were violations of their copyright in the dance and other types of IP as well. And the copyright lawsuits generally failed primarily because this all happened around the time that the Supreme Court made it clear that you had to have a copyright registration before you could file suit. And none of these were registered up front. The Copyright Office has generally said that just like choreography and the dancing, you can't copyright individual dance steps. And so most of these were very short, 20 seconds or less. And the Copyright Office has generally said they're not copyrightable. Some people have managed to get copyrights on longer dance moves. So you have half a minute of, you know, clearly choreographed dances. And so copying that might be an issue. Other people have said, hey, I've got a viral video. I think it was the Backpack Kid. And they were able to get a copyright on the video itself. And so a copy of the dancing from that video might be sufficient for them to claim a copyright infringement. But most of those cases have been tossed, and now the ones that have been refiled are focusing instead on rights of publicity, suggestions that there's endorsements and the like. But this is a hard sell. But you do understand from the actors and you know, point of view, you know, they've made it public. This is their signature move, and somebody else is making money off of it. So you know, these types of lawsuits are expected, even if they're difficult to win. Next slide. So moving on to trademarks. You know, trademarks identify the source of a particular goods and services. In this case, it's going to be the source of the game or the various components in it. And just in brief summary, the purpose of a trademark is to protect against the likelihood of customer confusion about where a product is from or who sponsors it. And in the context of game development, you can protect the game name, the title of the characters, the logos, the engines underneath. I know when I start a game, you know, I'll see half a dozen different trademarks pop up on different aspects of the game, from the manufacturer to the characters to the, you know, the engine to the company that's distributing it. So here's just a couple of examples of those that I'm sure some of you have seen before. But as you develop the game, you think about the trademarks that might be protected. And you also want to make sure that you don't infringe anybody else's trademarks. So can we pop to the next slide? And one area of where people need to be careful is in choosing what are you going to call your name. What name are you going to give your game? There's a lot of choices, but you generally have to pick a small name. And the safest bet, along with any other type of branding, is to do a search to make sure that you're not picking a name that's already trademarked or one that is similar to what's already out there. And as an example, there was a game came out, the Alien Wasteland from Davidian Games. It was sort of a very basic pixelated shooting game, but there was a much more sophisticated post-apocalyptic world game called from In Exile called Wasteland. And when Alien Wasteland started to come out, In Exile complained that it was a trademark violation. And even though they, you know, the program had been released and everything, they had to go back and rename it Alien Action, or Action Alien. Similarly, Iron Maiden sued a company that released the Ion Maiden, and that you can see that there's some issues there. There was a settlement in that case. The game was renamed Ion Axis, but it's always easier to get it taken care of ahead of time rather than spend all your money on branding and designing your logos and, you know, publicity and then have to change it after the fact. But you do need to be aware that you can overreach. Just an example, the owner of Candy Crush Saga, at one point went after every app in the Apple Store that had the word candy in it. Similarly, Doodle Jump went after any game with the word doodle. And this was a bit of an overreach, and those were eventually dropped when enough people complained. But there is, it can be difficult to tell exactly where they are, particularly because, there are only so many names to choose from. So just don't pick one that has words or phrases that are the same as the really popular games, particularly by the big parties. The second issue has to do trademarks with how do you use trademarks in the context of your game. And this comes up a lot when you have games that include 3D environments or replicated environments like cities where you're moving around and they have examples of other people's works in them. And it's a balancing act between whether you have the right to your trademarks versus First Amendment right. And the standard test, it's called the Rogers test, is that you can use a third-party trademark in the game, and it's way similar that you might be able to use it, for example, in a movie, unless you're using it in a way that has no artistic relevance to the underlying work, so it's completely gratuitous, or you're using it in a way that it might be artistic, but it suggests that the owner of the mark is in some way sponsored or is the source of the work itself. And so as some examples moving forward on the next slide or two. So here's some examples. In the Grand Theft Auto show, they had you drive around in the city. I think this is in LA. And one of the stores that they replicated was a strip club, the Pigpen Gentlemen's Club. And there was a lawsuit saying that they stole their trademark. The court looked at this and said, this is really just part of the environment. Nobody watching this game would think that it was sponsored by the playpen, and so the First Amendment rights were up. First Amendment rights went out. Excuse me about the phone. Similarly, Mil-Spec Monkey, they make these badges, and one of the military games had a copy of that badge, or a very close one, among all the other things that they could use to accessorize their players. And the basic ruling of the court was that this is, and nobody would think that they were a sponsor, but this really helps make the realism of the game, all these combat badges and things like that. It's what you would expect. And that was fine. As a counterexample, you can see on the next slide, this was another battling game, but in this case, it was really focused around the Bell helicopters. And when they first brought the game out, they had actually gotten approval from Textron to continue to incorporate the Bell helicopter and a lot of information and materials about it into the game. But when they decided not to renew their license because they got tired of paying the fees, they got sued for trademark infringement. And the court looked at that and said, well, it's part of the environment, but you're using it so much that somebody using your game could logically think that the Bell helicopter was a sponsor of the game and that they were part of it because this is, was a central component. And so even though they had to put a disclaimer saying that this has nothing to do with Textron and Bell helicopter, the court allowed the lawsuit to go forward, and that eventually settled. But that's sort of an example of where it's going to be prominent as opposed to a background. And so, I mean, you obviously always want to ask, but this is something that actually came up about a week ago. There's a gentleman, Mr. Vladimirov, who wanted to make a game involving SpaceX, and he said, I'm going to post a Twitter post every day for a year until I get a yes or no from Elon Musk about whether I'm going to be able to do it. And Elon last week responded with the very cryptic thing, yes, you can steal our name and logos and we probably won't sue you. So, it's asking can be useful, but I don't know whether this makes it better or worse, whether they can steal the name or logos. But you have I suppose it also depends on how he's using it. If he has a Mars colonizing game and there's a spaceport where one of the hangars is SpaceX and another one is Boeing and another one is Delta and one is, European Space Agency, you might argue it's just part of the background. But if it's an alternative where it's you're playing SpaceX and SpaceX is colonizing it and they're the central player, then that's probably not okay. And I think having the post and getting this type of response might actually have made it worse off for the guy than just keeping quiet. But it was interesting. And the use of Elon Musk in the game also raises questions about the rights of privacy and rights to use your own name and likeness in a game. So we can move on to the next slide. It's the last issue I'm going to talk about. It has to do with rights of publicity. And issues happen a lot in games where you have recognizable people. These are publicity rights and they vary state by state. But in general, we can see on the next slide or two that if you're using a person likeness and you have their name and they're doing what it is that they're known to do, then you're going to get into problems. On the other hand, if you're using something that maybe looks similar to them, but you're transforming it in some way, they're a totally different environment. Instead of a football player, maybe they're an astronaut, and they might look like Tom Brady, but it doesn't say Tom Brady on it. They're doing different things. You can argue that it's a transformation. It doesn't really link into the person's identity. And so you're probably not going to have to worry about using that. If you have customizable characters, a lot of characters let you change it. You can't always control what your users do, but look at how the default setting is and make sure that at least as it comes out the door, it doesn't look and act and sound like the person that you're inspired by. On the next slide is an example of two cases where people sued for rights of publicity. There's Lindsay Lohan. Again, Grand Theft Auto, they seem to be caught up a lot in these things. Lindsay filed suit in New York. There were a number of lawsuits. They were dismissed. They were appealed. They were overruled. They were appealed and dismissed again. And ultimately, what the court ended up saying is this was a generic depiction of a person. It's similar to Lindsay Lohan, but you're not using her name. It didn't specifically say what she was doing, but it's a generic, blonde beach girl with a popular sign. And even if that was Lindsay's signature move, it wasn't enough to link her definitively, and it was viewed as transformative. Similarly, pop singer Kirby sued a game company that had a character that looked similar to her, had the same catchphrases, but instead of the type of dancing that she did, this was a space game, and they had her doing some different things. And the court there found, again, it was sufficient to transform them in protective expression. Areas where it's not going to be good, we'll flip to the next slide here, is where they're doing what it is they expect to do. This was an NCAA football game. This lawsuit was probably about 8 or 9 years ago. But in this case, it was, even though the name was not there, everybody could tell who it was. It looked the same. The teams were the same. The user statistics were the same as the person's, which is what you want in these sports games, because people like to play with, characters that correspond to real players, but they didn't have the rights to do that. And here the court said it was not a transformative use. They didn't allow it. But now a lot of the professional sports leagues and schools all address this in the contracts. And so if you look at a professional football player, soccer player, you read the contract at the bottom, somewhere it's going to say that the league has the right to use their name and their character in sponsored video games. And so it's less of a thing now than it used to be, but these are examples of ways in which you can or cannot use real life characters in a video game. So a couple quick takeaways since we're running short on time. Just when you're developing a game or you have a client that's developing a game, go through the list of potential types of IP that you have and make sure that you document it and you have contracts in place that you own it or that you license it for a certain period of time. And you consider how you can keep that licensed material as time passes. There are games that have been very successful that had popular music in them, for example. And when the license to the music ran out, those games had to be pulled from the stores because they hadn't figured out, hadn't thought ahead. What were they going to do? Or they couldn't use it in a sequel, for example. And when you're using third-party branding, trademarks, and people, just be careful about how they're used. And on the flip side, people that are playing games, the key thing, be careful what music you play in the background, and don't do anything that makes it look like you're making money. So no ads, no no t-shirts or anything that might suggest that somehow you're freeloading off of somebody else's game for your own profit. And then check the end user license agreements, because you might be allowed to do it. They may be specifically prohibited, but if there's money involved, then you have a risk. So I think we're pretty much out of time. Thank you.